Well, welcome everyone. Those of you who have joined us in person at the National Press Club for our briefing on bringing science to bear in Fisher v. University of Texas, Austin, and those of you who are joining us virtually through the modern technology of live online transmission. I am Felice Levine, Executive Officer of the American Educational Research Association, and it is my honor to preside today at this briefing. 2 days before the Supreme Court hears oral arguments in Fisher v. University of Texas at Austin, we are very pleased to have all of you joining with us for this important briefing on the scientific evidence on the educational benefits of diversity, the use of race in university admissions, and the consequences of Fisher for higher education and the STEM workforce. AERA is the largest national research association devoted to the scientific study of education and learning. This event, as with the Amicus brief that AERA and 9 other scientific societies filed last month, exemplifies one of the key objectives of AERA as a scholarly association. That is to bring rigorous and relevant knowledge to bear on salient education issues. AERA has a fundamental interest in the accurate presentation of social science research on important questions of law and is committed to public policies based on rigorous scientific evidence. As a scholarly society, we see educative briefings like this one as critical in making more accessible to the public and to helping to clarify the state of our knowledge on compelling and important issues. This is not an issue that's an abstraction. The campus racial justice protests at the University of Missouri and others across the country in recent days capture media attention, and they speak not only to the significance of the issue of diversity, but the compelling interest that the state has in the issues that underlie Fisher. There is a need for research on these issues to be brought to the forefront and shared broadly with the public, and that is a key objective of why we are here today. AERA has long been committed to sharing the research evidence that demonstrates educational benefits of a diverse student body in education generally and in higher education in particular. AERA filed an amicus brief in 2012 for the Supreme Court's first consideration of the Fisher case that has been returned to the courts this year. We also filed research-based briefs in 2002 for Gruder v. Bollinger and Gratz v. Bollinger, and in 2006 for parents involved in community schools versus Seattle School District Number 1 and Meredith versus Jefferson County Board of Education, a K-12 case. The scientific associations that joined with us on this brief are similarly committed to bringing the best of the scientific knowledge to bear on compelling issues of public importance in society. I want to acknowledge each one who joined us on the brief, several of whom are co-sponsoring this briefing. The American Anthropological Association, the American Association for the Advancement of Science, the American Political Science Association, the American Sociological Association, the American Statistical Association, the Association for the Study of Higher Education, the Law and Society Association, the Linguistic Society of America, and the National Academy of Engineering. Today, we will hear from 4 expert speakers who have not only made vital contributions to the preparation of the AERA's brief and related research briefs, but also have contributed broadly to the social science knowledge base and to better public policy making based on this science and research. We are altering the agenda for those in place and have the agenda before you. And so we will somewhat shift the order, showing that flexible remedies can matter at compelling time. So what what we are going to do and how I will shift my introduction is that, that the second speaker after Angelo Anchetto will be Liliana Garces, who will be addressing further with a deeper dive drill down the benefits of diversity. And then Gary Orfield will take up the theme of how to best achieve these benefits and the strategies for achieving these benefits, focusing on, in particular, narrow tailoring approaches. So our first speaker, if I can make the jump from one to another, Angelo Anchetto, will discuss the legal context of AERA's Amicus brief and the importance of social science research in informing the work of the court. He will also provide a brief overview of the benefits that drove the brief and our considerations. Angelo is counsel of record for the most recent AERA Amicus brief and has led in the preparation of all of the research amicus briefs filed on AERA's behalf. Angelo served as Associate Clinical Professor of Law at the Santa Clara University School of Law from 2005 to 2014. He has also served as a lecturer at the Harvard School of Law and the University of California, Los Angeles School of Law, and as Adjunct Associate Professor of Law at the New York University. He has, in addition to a law degree, an MA degree in public policy, and ever the student and scholar, he is currently completing a PhD in political science. Angelo will be followed by Dr. Liliana Garces, who will address in fuller relief, as I just mentioned, the benefits of diversity on campus. Liliana is an assistant professor of higher education and a research associate in the Center for the Study of Higher Education at Pennsylvania State University. She has both a law degree and a doctorate in education. Like Angelo, she has served as counsel of record for research amicus briefs, including the most recent amicus brief on behalf of 823, got that number right, social scientists, and there's copies of that brief on the back table. And it's also, for those joining us online, it's also posted on the AERA website. Liliana will be followed by Dr. Gary Orfield, as I noted, who will address strategies for achieving the benefits of diversity with particular attention to narrow tailoring. Gary is Distinguished Research Professor of Education, Law, Political Science, and Urban Planning at the University of California, Los Angeles, having many students. He's mentored in all of those locations, and he's co-director of the Civil Rights Project at UCLA. For decades, Gary is among the leading scientists in the field, bringing rigorous, exacting standards to his work and to all of us working with him. He is an editor or co-editor of 5 books on opportunities in higher education, including Diversity Challenged, which was cited by the Supreme Court in the 2003 Gruder decision. Our final speaker is Dr. Shirley Malcolm, who will talk about the consequences of diversity on the U.S. workforce and STEM education. Shirley is head of the Education and Human Resources Program at the American Academy for the Advancement of Science, where she works to improve the quality and increase access to education and careers in STEM fields, all STEM fields, as well as enhance public science literacy. She is a guiding light in the significance of her contributions to STEM and the STEM workforce. She is a trustee of the California Institute of Technology and a regent of Morgan State University. She is also a former member of the National Science Board and served as President Clinton's Committee of Advisors on Science Technology. My job is relatively easy. Once I made that nice switch of the order, that was my major challenge. I'm going to try to monitor the time closely, of course, and so that we have really ample time with such a nice turnout here, and we hope online as well, to really be able to engage in the educative briefing that really brought us to schedule this 2 days before the oral argument. For those who are live tweeting today's event, we are using the hashtag Fisher v. UT, Fisher v. UT, which is not case sensitive. Our speakers will give brief opening remarks in turn. We will follow the order as I have restated the order from the agenda. And with that, I am very pleased to turn it over to Angelo Ancetta.
Thank you, Phyllis, and good afternoon. Well, here we are again. It seems we've been here multiple times, and we have. And I think the role for us today is to try to cover both what we know and what has been researched and what has been documented and what has been filed before the court, as well as to think about where the court might be going after the Fisher case. So I'm going to actually do a little bit of, time permitting, I'll do a little bit of prognostication, but I do want to spend some moments refreshing our memories and talking a little about the legal framework and then discussing to some extent what's covered in the AERA brief. Now, as you know, this is the second time that the Fisher case has gone to the U.S. Supreme Court. It went up to the court, and the court rendered a decision in 2013, but it essentially was a procedural decision, saying to the lower court that you didn't apply a strict enough standard in reviewing this case, therefore we're going to send it back to you, look at it again, and then make a decision. And the plaintiff in this case decided to appeal it once again to the court. Now, as Felice mentioned, this isn't the first affirmative action case that the court has dealt with. We know the fairly long history of race-conscious admissions in the court, and we thought it had been clear in the Gruder case that the case for diversity as a compelling interest in higher education had been made, and I would argue that it has been made. But the plaintiff in this case is continuing to relitigate it. I think certainly if you look at the earlier filings in the case, the plaintiff wanted to actually overturn Gruder. They are still trying to address the compelling interest question, even though I think that is a settled question. And even though this case should be largely about narrow tailoring, the second element of the court's strict scrutiny test, we're still covering compelling interest, which is why if you look at the AERA brief, quite a bit of time is spent on compelling interest. If you look at other briefs, including the 823 social scientist brief, there is much more attention to what should be the core issue, which is this policy that the university has adopted narrowly tailored to its interest in diversity? Again, the court could, in this case, overturn Gruder. I think that's unlikely. Given what we saw in the first case, there were not 5 justices who wanted to overturn it, but there certainly is a lot of skepticism. And as we saw in the earlier case, it is no doubt Justice Kennedy who will be the swing justice in this case. The case has an unusual procedural posture as well because one of the justices, Justice Kagan, is not participating because she was Solicitor General prior to her appointment and her office worked on the case. There are only 8 justices deciding this case, and in close cases that one justice being out of the case makes a big difference. So given what we think will likely be the vote in this case, Justice Kennedy's vote becomes very critical. We are probably not going to see a 5-4 vote or five votes in favor of the university. We could see a 4-4 split, which in essence leaves the lower court's upholding of the policy intact. Or we might see a 5-3 decision where the court strikes down the Texas policy, but I would think upholds most of Gruder, but does try to give some guidance, and this is a question we have to think about. What will universities do if you can't employ a race-conscious policy in tandem with a percent plan? So that's an important question. So what are we addressing here? Well, again, there's 2 elements to the court's strict scrutiny test. One is the interest compelling? That we thought was settled in Gruder, but the plaintiff keeps bringing it up. And there are elements of that test that the court will likely talk about on Wednesday. And then is the policy narrowly tailored? So with respect to the compelling interest argument, there is a well-developed body of literature. It has expanded, certainly even within the last 3 years, it has expanded significantly, that says that the interest in diversity is in fact valuable, that it's important, that it's compelling, that there are inherent benefits associated with diversity in higher education, whether it is cross-racial interaction, reducing prejudice, improving learning environments, classroom environments, student living environments, campus climate, a wide variety of benefits associated with diverse student bodies. There are harms associated with racial isolation and tokenism. These include stereotyping, a phenomenon known as stereotype threat, where students may in fact perform more poorly because they perceive that stereotypes against them will be problematic in their performance. There are areas of stigma that can arise, even increases or relationships between hate crimes and violence and low diversity environments. So there is a strong case for the compelling interest argument. The narrow tailoring argument, which again other panelists will cover in more depth, is critical as well because that goes to how the policy implements the interest in diversity. And what are key elements of the narrow tailoring inquiry include, is there a quota involved? Is there individualized consideration? Are other factors other than race being considered? Is there periodic review of this policy? Will it end at some point? Will it sunset? Do race-neutral alternatives work just as well? One of the key issues in this case, and it's the issue that may indicate how the court is willing to uphold some policies but not others, is when you have a race-neutral policy like a percent plan, as Texas employs, and you also employ a race-conscious policy, can those be combined together? The argument that the university makes, and I think it's a strong one, is that race-neutral plans, like the percent plan, don't work as well. They do help with the diversity enrollments, but they don't do as much as you need to in terms of promoting racial diversity. So if you do that, and you employ a policy that the court in Gruder has upheld, what's wrong with that? What's wrong with that? Those are key empirical questions, because you do have to show that the race-conscious plan is necessary, that the race-neutral plan doesn't work as well as it should. I think the case is very strong for that line of argumentation. Final point, and we can cover this more in the Q&A, I think it's likely that we're going to see a decision where the court is divided. I don't think that's in doubt. But we're probably going to see one of two decisions. The court will either split. Justice Kennedy will vote to uphold this lower court opinion, or we'll see an opinion that's 5-3, and Justice Kennedy will try to carve out some sort of test that will not uphold the Texas plan, but will uphold race-conscious admissions in some form. I think that raises some very difficult questions about what actually could work, because as we'll see in this panel and through further discussion, other plans just don't work. The 10% plan doesn't really work as well as it needs to. Other sorts of policies like socioeconomic and class-based admissions don't work as well as they should in terms of promoting diversity. All of these elements make it very problematic in terms of employing policies that don't look directly at race. So I think that's going to be the key issue before the court. I expect to hear it in some of the oral arguments, and we'll see how that case comes out once the court issues its decision in the spring.
Thank you, Angelo. Thanks, everyone, for being here, and thank you, Felice and AERA, for the invitation. Well, it's a complicated case. It's before us we're here. We find ourselves for a second time. But I would say that one clear message from the first round of the case from the court is that race can be used for the educational mission of institutions as long as it's done in a limited manner, in a narrow, tailored way, which is what the court asked the lower court to assess and what the court is reviewing to see if they did engage in that determination. But because amici for the petitioner in this case have challenged this prior precedent upholding the compelling interest, and even though the petitioner's lawyers in the first round, when asked at oral argument, said that was not an issue that they were presenting to the court, the arguments that they raised in their briefs make it look like they are indeed challenging these questions of compelling interest, which is why it's important for us to address. Professor Gary Orfield, as Felice mentioned, will be addressing the evidence that speaks to this question of narrow tailoring. And my comments are going to expand a bit on Angelo's comments with respect to a couple of nuanced points that the case raises regarding the compelling interest of diversity. The first is the issue of critical mass. The second is the question that UT Austin has framed as diversity within diversity. The fact that they are trying to obtain students with different socioeconomic backgrounds within racial groups. And I'm going to end briefly by discussing research findings on the harmful consequences that eliminating the consideration of race as one factor in admissions altogether would have. A potential outcome in this case if the court were to say that only race-neutral policies could be followed or implemented in order to obtain the benefits of diversity. So first on the question of critical mass. Those of you who listened to the oral argument in Fisher might remember the instance when Justice Scalia asked the lawyer for the government about this question of critical mass, and Justice Scalia suggested we should stop calling it critical mass. We should call it a cloud or something like that, because mass assumes numbers in size or weight. And Justice Scalia is raising an important point on this question that relates to how we frame this concept and how we understand it within the legal community. In fact, when lawyers and educators sometimes talk about diversity in post-secondary education, as well as this concept of critical mass, we talk about it primarily in terms of numbers or percentages of students of color on college campuses. And numbers, of course, are important. They matter. They help prevent isolation. But any attempt to provide a one-size-fits-all number, absent other contextual determinations, would undermine the complexity that is at play and falls into the legally impermissible area of quotas. And what the research reveals is that thinking about critical mass in terms of just numbers, they matter, but only numbers, reflects a very limited understanding of the concept. And it pays very little attention to the support mechanisms that need to be in place in order to generate the educational benefits of diversity. In other words, the relationship between the institutional context and the students. And so just as important as numbers are the interactions among students that take place, the particular context in which those interactions are taking place, the environmental conditions that need to be in place for the benefits of diversity to emerge. And what social science research teaches us is that there's 4 conditions that are necessary. First, you need a positive racial climate that helps instigate the productive interactions among students. Second, you need to attend to the historical legacies of exclusion at a particular institution. Third, you need to attend to the impediments for productive interactions in learning environments, in classrooms, right? That would be in the case of just having 0 to no students of, or to 1 or just a few students of color in a classroom. And finally, you also need to pay attention to the nature of cross-racial interactions that are taking place. And what UT Austin's policy is looking to do is to help create all those conditions. Now, with respect to the promoting cross-racial interactions, that relates to the second point of diversity within diversity, which is, again, a goal that is fully supported by the research, which shows that having socioeconomic diversity within racial groups helps facilitate cross-racial interaction across groups. So having socioeconomic diversity within, let's say, African American students helps facilitate interactions between African American students, white students, Latino students. And that interaction helps counter stereotypes that minority students are monolithic, that they think or behave in the same way, or that they share just a monolithic set of circumstances or backgrounds. And given the number of incidents across the country, with Black students expressing feelings of isolation, disempowerment, as they continue to experience hostility because of their color of their skin, policies that help colleges and universities address those challenges by promoting cross-racial interactions are more critical now than ever. Now, my final point relates to findings from research that also teach us that a decision that would restrict UT Austin's ability to build a truly diverse student body would only exacerbate the tensions that we are seeing across the nation. Studies have shown that public institutions that cannot implement race-sensitive admissions because there are states that have banned the policy have experienced substantial declines in racial diversity. These declines have taken place at selective institutions across the country, in different professional fields, including medicine. Before the laws, in just the field of medicine alone, before these laws, for every 100 students enrolled in medical school, there were about 18 students of color enrolled. Now, that's already a pretty low number. And some of my research shows that after the implementation of these bans, for every 100 students matriculated in medical schools, there are now only 15 students of color. And there also have been declines in the field of engineering, which Professor Shirley Malcolm will address. Now, preventing the consideration of race in admissions can harm both majority and minority groups by allowing harmful racial stereotypes to operate without policies that can help counter those stereotypes. One of my recent studies that was also examining at the impact that Proposal 2 in Michigan had found that beyond just leading to also declines in racial diversity in the student body, this law had the influence of affecting the work of administrators on campus. They talked about feeling at the University of Michigan, they talked about feeling less empowered to undertake this work, of not being able to talk about racial diversity as much, to make their efforts in support of racial diversity much less visible. And in the wake of incidents like those at the University of Missouri, that's the exact opposite of what we need for institutions. They should be able to have every tool at their disposal, including race-conscious policies, to be able to address those challenges.
Well, we're going to turn now to what I think is really the central question that's before the court, which is there a non-racial alternative that will produce diversity at what the Supreme Court called tolerable administrative expense in the first Fisher decision? And basically, our review of the research that was done by groups of scholars from across the country and signed by over 800 researchers from 46 states concluded that there was no feasible non-racial alternatives that would produce significant diversity at tolerable administrative expense, and that the three principal alternatives that have been talked about, the percent plan, the use of social and economic status, and the special outreach, preparation, and recruitment efforts, have all been tried massively, particularly in places like California, which has now 19 years of experience, spending billions of dollars trying every alternative, and that they have failed. The best evidence that none of them can work comes from a series of evaluations. The percent plan, which is the main thing that's that is being looked at in the UT experience as undergraduate admissions, since it's only used for undergraduate admissions, is one of the most extensively researched innovations in higher education policy. There's a great deal of research on it, which is cited in the brief of the American social scientists. And this percent plan, by the way, is now the 7% plan, since the demand is so high that the university isn't able to accommodate the top 10%. What we basically find in that research is that, of course, the numbers of students of color did recover from its low point after the Supreme Court decision, after the affirmative action ban by the Court of Appeals in 1996. But the recovery, when you analyze it closely, as it was analyzed, for example, by a gigantic research project at Princeton University and a number of others, really is a reflection of the changing demography of Texas. Texas has had a dramatic decline in the percentage of whites in the college-age population, a dramatic increase in the percentage of Latinos, and a relatively constant percentage of African Americans since the first affirmative action ban back in the 1990s. Basically, what we see is the number of Latinos has grown significantly on the UT campus, but the relative access of Latinos to the UT has actually declined. What we're seeing is a partial reflection of a tremendous demographic revolution, which is being interpreted as a sign of the effectiveness of a percent plan. That's not to say the percent plan should be abandoned in any case, but that it has not solved the problem by itself, which is why the University of Texas went to restoring affirmative action after the Gruder decision. After Gruder, the University of Texas wanted to have some flexibility in admitting what it considered the most qualified African Americans and Latinos and others from other racial groups that didn't happen to fall in the top 10 or now 7% of their high school graduating class. Because that's a very mechanistic approach, and no admissions office wants not to be able to admit somebody who has remarkable talent and doesn't happen to fall within one particular statistic. What we see in the percent plan is that there has been a substantial growth in the percentage of Latinos, but the percentage of African Americans is only 4%. This is even after the restoration of affirmative action. Texas has the third largest African American population in the country. It has been bitterly discriminated against historically, before and after the Supreme Court outlawed discrimination. The Supreme Court made several decisions, actually, about Texas discrimination against blacks. By any standard, 4% of students isn't enough to have a substantial presence and to really create a diverse setting for students interacting with the African American population at the University of Texas. What we see in the briefs of the plaintiffs is that they just add the Latinos and blacks together as if they're interchangeable groups, and they can just add the number together without thinking specifically about what's happened to African Americans. The Supreme Court's own jurisprudence says that's incorrect. They made that very clear in the Parents Involved decision, for example, and many others dating back to 1973. What we see in Texas is that there are lots of virtually all Latino high schools. The percent plan relies on segregation. There are very few all-black high schools because most blacks in Texas are in predominantly Latino schools. So the percent plan does not come up with very many schools where you'll automatically have African Americans in the top 7%. What we see is that there are many highly qualified blacks and Latinos in integrated schools that aren't in the top 7%, but they could, the University of Texas knows that they could succeed and they would add to the diversity of the university. So this is a question about whether the court should make that impossible. In terms of SES discrimination, there are now many research studies, including a brand new one by Sean Reardon and others at Stanford University, that show that SES does not work effectively as a proxy. Race and poverty are two different things. They overlap, but using poverty by itself does not produce significant racial integration, in part because there are many low-income students, particularly new immigrants, who have very highly educated families, but do not have much current income. And they tend to be advantaged greatly by SES preference. What we also find is that very few colleges in the United States can afford a non-racial SES preference, because we have very few colleges that actually admit students in a truly need-blind basis and give full necessary aid. So it would be administratively and financially impossible for most of our states to do that on any large scale. Right now, almost all of our big colleges are looking for high-paying students internationally and from other states to make up their budgets, which have been cut radically by cuts in state and federal assistance to higher education. The other alternative, which is to look out, to try to do outreach, recruitment, and support, has been tried massively by the University of California for 19 years since affirmative action was banned. It has been a failure. The University of California has invested invested billions of dollars in alternatives. Those have included early training programs, special recruitment, many other race-blind alternatives, including a percent plan. The university's access, the gap between access for blacks and Latinos and whites and Asians has actually increased in spite of all those programs. And this is in a state where the vast majority of the young people growing up are non-white. So none of the alternatives actually have any research evidence to show that they'll work, and there's good research evidence to show that they haven't worked. And they also to show that the administrative expense of trying to do this partially in a race-blind way would be tremendously high, more than could be afforded in state budgets. The University of California has tried everything and also has an extremely generous financial aid policy and extremely high presence. The last point I'd like to make is that most of the schools that are doing race-conscious admissions are also already doing affirmative action on the basis of poverty. We found that about 2/3 of the schools that were surveyed by the American Council of Education who do race-conscious admissions are also doing poverty-conscious admissions. And the University of Texas is one of them. Texas has the 8th highest presence of Pell Grant students among the leading universities in the country. So for these universities, it isn't either or, and it isn't that we replace affirmative action with SES affirmative action. We already have it. We'd be subtracting the race-conscious part of the policy from a dual policy that most selective universities believe both components are necessary. We can talk about the research on many of these issues as our discussions continue.
The AAAS support for the AERA Amicus rested on really two issues. One, that the need for the highest quality research to be available to the Supreme Court, to be considered and used in the arguments before the court and in the decision-making related to Fisher v. University of Texas at Austin et al. And the second really related to the special challenges to institutions as they undertake efforts to not only to diversify their campuses, but on the harder job of diversifying STEM fields on their campuses. Including among STEM fields are those that support the study and research related to compelling national interests, such as economic and national security, food security, climate change, human health, and much more. For over 40 years, AAAS has affirmed the importance of increasing diversity in education and employment in STEM and related fields. And for over 40 years, we have noted how difficult it is to realize this goal. Much of the research that you have heard from my fellow panelists informs the nature of these challenges. The numbers of individuals from underrepresented minority groups enrolled in pursuing degrees in programs in these fields is small nationally. And so by the time you get to the level of a single institution, those numbers are really small. Diversity within an institution is important, but in the context of science, mathematics, engineering, technology, medicine, and these kinds of related fields, the action is in the classroom, the laboratory, and the research group. The AERA brief references research related to, quote, minority students in racially isolated educational settings as being at risk of significant harms, including stereotyping and discrimination that can undermine their academic achievement. It further observes isolation, subordination, and negative stereotyping, a commonplace in settings where minority numbers are especially low, and the norms and behaviors of majority groups dominated. Guess what? They just finished describing STEM departments and programs. The fact sheet outlines some of the data related to enrollments and degrees. It's not difficult to imagine how small these numbers can get within a department, such that isolation becomes the norm. But it is important to consider the possibilities of how these numbers might be increased. There have been increased participation by underrepresented minorities in higher education in general. Among these groups, there is strong interest in majoring in STEM fields. While there are losses of these students from STEM majors, often after introductory courses, research is revealing new effective pedagogies that can begin to address this. At present, however, there are losses at each successive level of study. In 2014, for example, 9,568 doctorates were awarded in engineering. Only 167 of these doctorates were awarded to Blacks, and 243 to Hispanics. That's how small the numbers are when you are looking at a pool of individuals who might be considered future faculty. And in these particular cases, the numbers that I gave you are for U.S. citizens and permanent residents. Education is more challenging in these fields, where the presence of minorities is low. In addition to taking on challenging content, there also exists the need for these students to deal with assumptions about their capability and stereotype threat. Isolation and the difficulties associated with achieving critical mass, or if you would, supportive collegial environments. There's also strong evidence for the benefits of diversity in STEM and in innovation in general, consistent with the research that analytical problem-solving skills are positively related to the quality of the informal interactions with diverse peers, as are gains in students' complex thinking skills. These are the qualities that we wish to foster for all students in education in science and engineering. Assessing the potential of students to be successful in STEM fields goes beyond just looking at their scores and their grades, though these are important. In holistic review, one would need to look not only at the grades and the scores, but also at what barriers the students have overcome, whether they have had research opportunity and experiences, whether they have evidenced persistence or determination in other parts of their lives, and many more factors that they're likely to need in order to navigate these fields. One question is, how do practitioners use the science that is being cited to inform decision-making regarding students' admissions to program? In the absence of equality of educational opportunity in K-12 education, we deem it important to consider markers for potential, again consistent with holistic review. In the past, when legal challenges have appeared and when universities have been uncertain about how to manage the legalities around their intervention programs, we have seen a loss of ground in enrollment by underrepresented minority students. A 1998 policy study that was conducted by AAAS, called Losing Ground, documented the impact on graduate study in STEM by Blacks and Hispanics in the wake of the Supreme Court decision in AERA, the Hopwood decision, and the ban on the use of affirmative action in light of the ruling by the Regents of the University of California and Proposition 209. So in collaboration with the Association of American Universities and the Council of Graduate Schools, we queried 93 selected research institutions and asked what had happened before and after these things took place. As you can well imagine, we lost ground. And I think that this work, in the case of a policy review, is very much reflected in the careful research that was done by Liliana Garces, looking at public institutions in the 4 states that are barred by state law from considering race in admissions: California, Florida, Texas, and Washington. Her analysis showed that these bans led to declines in the proportion of underrepresented students of color in various graduate fields of study, including engineering, the natural sciences, and the social sciences. And our data indicated that the percentage of enrollees, that across these 4 states, the percentage of enrollees in graduate programs in engineering who were students of color declined from a pre-ban level of 6.2% to 4.6% after the bans were enacted. Today, we actually see a decline in the presence of African Americans in engineering. So things are not basically getting better, they seem to be going south. While STEM fields pose special challenges, their importance, coupled with the massive demographic changes underway, require that we find a way to attract, retain, graduate, and sustain the presence of underrepresented minorities in these fields. Our economic development, national security, and the health of our country require it. The challenges to institutions to respond to the compelling national interest in having a quality, diverse STEM workforce are exacerbated where universities are not permitted to use race and ethnicity as elements of their decision-making.
Thank you, and thank you all. And what we're going to do is really just open it up for questions, both here, comments, things that are still puzzling to you, and if you wish you had more of an understanding, would help you better ferret out what's at issue, both in this case and more generally in higher education. Can I open it up? Yes. And just state maybe your name and institution so we have it.
Sure. My name is Brenda. I'm with National Council of La Raza. We're the nation's largest Hispanic civil rights and advocacy organization. And my question is for Dr. Orfield. You mentioned the demographic revolution happening in Texas. Can you just discuss sort of this growing population of Latino students and how these policies have a disparate impact on them?
Yes. It's not just in Texas either. Of course, both in Texas and California, most of the children being born today are Latino. And we're going through a situation in California where only 1/4 of the students are white. The country's changing. And if you have the same admissions process, you will get, everything else being equal, more Latinos, and because the white proportion is declining, a proportion of Latinos is higher. So whether you attribute that to a policy or to the demography is the important question. Most of the researchers say the fundamental growth and recovery of Latino enrollment at UT is demographic, because so many more qualified Latinos are existing in the population as the 20 years passes since the first percent plan was adopted. The really important thing to think about the demography is what kind of a society are we going to be if we don't figure out how to educate students of color? Because we've increasingly segregated them in the public schools. In California, there's about 10 times the likelihood that a white or Asian student will be in a high-quality high school as a black or Latino student. We just admit people on the basis of their test scores after they're segregated in completely unequal schools. We are going to perpetuate segregation and inequality and build it even deeper into our society. And as our society becomes less and less white, and more Latino particularly, we're going to have a decline in average education level if we don't figure out how to do something differently. This is not an issue immediately before the court, but this is part of the consequence of these kinds of decisions. Even before these cases, with affirmative action in most of our states, a black student has only 1/5 the chance of being in a highly selective college as a white student on average, and a Latino student only 1/3 the chance. So we're talking about a very unequal situation, even with affirmative action. If we lose affirmative action, it's going to become that much worse.
See another hand, yes. We'll give you the microphone.
Hi, I'm Virginia Stead, and I'm a recent graduate from the University of Toronto. I got my doctorate on my 60th birthday. I'd like to continue the development of more inclusive vocabulary that Dr. Malcolm initiated. If I'm quoting you correctly, Shirley, you said instead of critical mass, we talk about supportive, collegial, environments. I think that's a great expression that we should all take back with us today. And to Dr. Orfield, I would like to suggest that instead of talking about segregating, which I know is American and widely understood, I'm speaking as a Canadian, I would like to talk about underserved students of color, because every student in this nation, regardless of physical appearance, is entitled to an equitable, and by that I mean fair, education in the public school system. So when we talk about segregation, all we do is raise the race flag again, and I can guarantee you that there are people who are conditioned to ignore that and therefore tune out of the conversation. But if we talk about underserved students rather than segregated students, maybe we can advance a little more interest in the conversation. Thank you.
I'd just like to respond to that second issue by saying, you know, these students are underserved, of course, and segregation happens to be the basic principle on which our constitutional law and these issues turns. The fact is that we have been resegregating our public schools under earlier Supreme Court decisions now for 30 years, and they're more segregated than they were 40 years ago. And that's consequential because these segregated schools are systematically unequal in terms of their AP classes, in terms of the qualifications of their teachers, in terms of the peer group, in terms of the instability of enrollment and teaching force, in terms of average health conditions, many forms of inequality are related to segregation. So whatever you call it, in our system, particularly when we're talking about constitutional law, the Brown versus Board of Education and its implications, and the Keyes decision that recognized the same rights for Latino students and the same history of discrimination matter tremendously in our legal context. But of course, these students are underserved badly.
Any other comments from the panel on that? Shirley?
I mean, I could sign on to changing the language. It's just that the language is sitting there inside of the decisions. And so we talk about critical mass. You know, when I was in graduate school back in the Stone Age, in a science-related field, as an African-American woman, essentially critical mass for me would have been one other person, because I was the only one. You know, and so but I'm totally fine with the idea of adjusting this notion to the context, to the larger context that actually applies when you have an environment that supports your learning.
And on the question of critical mass, my colleague Uma Jayakumar and I have tried to advance a different term, to think about it as dynamic diversity, so that we can focus on not just the numbers, but the interactions that need to happen among students and those conditions that I mentioned that need to take place for the benefits of diversity to come up.
Other hands? Yes, to the right, was there?
Hi, John Young from the International Baccalaureate. This is a question for Angelo. In your opinion, how likely is it that the court will take this case as an opportunity to re-examine and perhaps overturn Gruder?
Well, I can guess at it. I mean, I don't think they're going to overturn Gruder. I don't think Justice Kennedy wants to do that, but I think he's very uncomfortable, as we can tell from earlier opinions, not only in higher education, but in K-12 and other race-related cases. He's uncomfortable with race-conscious policymaking. So I don't think there are 5 votes there to overturn Gruder. I think there are 4 votes. So we're very it's very close. I think, I'm just sort of trying to read Justice Kennedy's mind. I think he may be struggling with, well, maybe I don't want to abolish all of these programs, but if I strike this one down, what am I leaving, right? So as we've discussed earlier, a percent plan does not give you the numbers that you need. Socioeconomic or poverty-based preferences do not, they promote socioeconomic diversity. They're very good at doing that, and schools try to do both. But they don't get you the racial diversity, outreach, and other sorts of programs and recruitment that are designed to promote higher application levels. Hopefully that would increase enrollments. Again, as Gary mentioned, nearly 20 years of experience in California as well as in other states. They don't work as well. So I think if I were Justice Kennedy, I wouldn't want to keep digging this hole. I might want to make this case go away. I didn't mention earlier that there are ways of getting rid of this course which are procedural. I don't think they're going to do that, but there are arguments, if you look at the university's brief, that look at procedural questions like, does this plaintiff actually have what's known as standing? Because from what we know from the admissions process, she wouldn't have been admitted anyway. Even if you didn't have a race-conscious policy, she wouldn't have been admitted. Is it all moot because she's already graduated from college? She's the only plaintiff in the case, so should she even be in front of the court? You could get rid of the case one of those two ways. You could maybe send it back to the lower court to get more fact-finding. That's a possibility. I suspect the court is going to they're probably going to want to decide this in terms of the merits. But again, your guess is as good as mine in terms of what the alignment will be.
Yeah, I would say on that front, trying to think about what the court's going to do is just mere speculation. We can engage in it and have some kind of informed speculation based on the votes and the rationale that Justice Kennedy in particular has illustrated in his past cases. But no one the first time expected a 7-1 opinion, that's for sure. So we don't really know what the court is going to do. But as Angelo said, we can think about the ways in which Justice Kennedy has voted in the past, and he has expressed concerns he's acknowledged that race matters. And so he is open and has endorsed a compelling interest in diversity at the K-12 school level as well as in higher education. His concern is with the means that we use to get there. And he's expressed concern about individualized considerations of race, which is what's at issue in race-conscious policies, finds them more harmful than a different approach, which he views as generally race-conscious, which essentially are race-neutral means in the case. And that's a distinction that doesn't quite get the support of social science research. I think research shows that race matters subconsciously. It's through implicit bias, through these other racialized psychological phenomenon. And so just getting rid of those individualized classifications isn't going to make it go away. It might reinforce the stereotypes that people walk around with. And so being informed by the lessons of the research on those questions is what we hope will come out of the case with the justices.
One of the things that Angelo said about the uniqueness of this case is one of the reasons why thinking about the research evidence is so important. Because this is a very strange case. It's not a class action case. It was about one woman asking for admission at one level in one campus. And the record is very limited. So, at the University of Michigan case, there was tons of research. It was a class action case. The students of color had their own lawyers representing them in the trials and in the process. None of that's true of this case. So this is a very thin little case on a what the university lawyers usually thought at the beginning was a trivial issue that should never be in the court at all. So that makes the social science research much more important. Because if we were to get to a decision determining the future of all of our universities on the basis of the record of this one girl applying to one campus that she wasn't qualified for anyway, it would be an enormous reach.
And I think it's very important to recognize also that in this period, since there has been change, there's been a tremendous amount of more research that has really been able to fill in and measure the consequences. So this was not a cut and paste of prior research to kind of bring it forward to 2015. This was really an integration of new bodies of knowledge, some of which have been discussed here, others of which are in the fact sheets in the briefing packet and will be on our website, and also are very, very, very well set forth in the research briefs. I think there's an online question, Laurie.
Okay. So this fall, we've experienced what can be described as a racial crisis across our nation's college campuses. Some view this as a negative effect of diversity. how does the research address such effects? Specifically, do educators play a role in mitigating the campus culture in ways that increase educational benefits and decrease negative outcomes, or vice versa?
The question was, do educators or do researchers?
In what?
Educators play a role.
Yeah.
I take it on campuses.
Absolutely. The leadership, the administrators, all levels at the institution play a role in creating those conditions to be able to help facilitate and promote that understanding. When you bring groups together that have not had the experiences of being together in the past, they might come from environments that are predominantly white, and they are challenged with understanding others. That is exactly what institutions are trying to do, is to promote those learning opportunities. And those are the times when we need the kind of support programs. We need the policies that give signal to students of color that they're welcome at that institution. And that's what race-conscious admissions policies can do. And that's why when we ban them, the consequences of eliminating them altogether goes beyond just admissions to the climate and the signal for students and what administrators can do to support those conditions.
Good whole scaffolding. Shirley, did you?
Yes, I think educators play a critical role. The only problem is that, at least in my fields, when you join the faculty, you are never taught about any of this. It has nothing to do with with the background or the reasons you're chosen to join the faculty. And in many cases, you just think it's just the facts, ma'am. And you don't realize that managing the interactions within the laboratory or within the classroom is actually critical to how these students are likely to experience all of this. And I think that that's a real challenge, beginning to understand the basis of some of the problems around the fact that faculty are not necessarily given the skills to manage this kind of interaction.
I see another hand here. Yep, go ahead, Liliana, and then we'll take your question.
Race is a difficult thing to talk about, but we don't get past it by then saying we're not going to look at it. We need to engage in its full complexity in order to get past it.
And when it's invisible, it becomes, of course, impossible. Another question.
David Hinojosa with the Intercultural Development Research Association, IDRA in San Antonio. A couple of facts that Fisher has thrown out there to the court are, one, that when you look outside of the top 10%, on the non-top 10% admissions, that the vast majority of those students being admitted into UT are white. So when UT can consider race, it apparently isn't doing a very good job of it. And then secondly, that the diversity within diversity, which I think, by the way, your brief, the contributions of your brief are just incredible within that area. But the record below doesn't really talk much about the diversity within diversity reach, and Fisher kind of argues, well, that's kind of after the fact that you're bringing this diversity within diversity. So I'm just wondering, how do you think, that those might impact, the court's analysis and decision? I know you said it's speculation, but I'm interested in hearing your thoughts.
Well, on the second point, I think it's important to know, and it's the plaintiff that's still trying to bring this up, and whether it's phrased as, and I think the university is using diversity within, it's still diversity, I think, in terms of how you look at it, but the petitioner is phrasing it as intraracial diversity. The university has sort of responded with diversity within diversity. I don't think anyone has ever said that having students of different economic backgrounds who happen to be of the same racial or ethnic category is not a good thing. In other words, we want to have a multiplicity of, and we want to have enough minority students that we can say this, that they come from different backgrounds, they have different experiences, they have different family incomes, that's important, that's salient, that makes a difference in terms of the classroom experience, in terms of interaction. That's important. And whether you phrase it as intraracial or diversity within diversity, that's on the whole contributing to the big picture of this is a diverse student body on our campus. And I think it's an odd set of arguments. I'm puzzled by it because I mean, frankly, I think the petitioner has a losing argument on many levels, and I think they're just sort of reverting back to what they think might be one that will have some resonance with the court. So to get back to your question, will that have more resonance? It's possible it might. Again, I think this is, to the extent this case should be in the court at all, it should focus on, well, is this policy necessary given that you have some other policy that you've been using for a number of years? And again, I think the answer to that is yes, you do need it. You don't have to go to court to actually answer the question, but I think that is a legitimate question to ask as a matter of public policy. I don't think it rises to a constitutional dimension at all because I think the court has been clear in terms of what is a permissible policy. There's really no difference between what the Texas holistic policy looks like and what was upheld in Gruder. So I don't know how the court, this is why I'm sort of struggling with what the court is going to do in this case, other than just saying, we think diversity is compelling, but we're not going to let you do it through any other means other than some race-neutral criteria. And that's what you're sort of left with if you follow the logic of where at least 5 of them may be going. So I'm not sure how they're going to sort of create some policy that actually works that isn't already a failure or just doesn't work as well as it should already in the country.
On the first question that David asked, it seems to me that one of the things that we need to think about at Texas is Texas was not very selective when the percent plan started. It's now much more selective, and it's going to be more selective every year because of the increasing demand. So without any kind of strategy like the percent plan or anything else, it's going to become more and more exclusive. And given the increasing segregation of the high schools and unequal treatment of kids in preparation for college, you're talking about a really threatening situation. Certainly, I think whatever happens in this case, it's important to keep the percent plan there, particularly for Latino diversity. And I do think the other thing about it is Texas' affirmative action component of its comprehensive review is weak. It really hasn't selected out very many students of color. It needs to be strengthened, in my view. It needs to be strengthened considerably. So you can have many different forms of affirmative action plan. Texas has a very moderate one, and there's another reason why the court should not be so eager to strike it down. It seems to me what the court's saying is if it doesn't do enough, it doesn't matter. If it does too much, we can't do that either. You get.
Other comments across the panel? Shirley?
I think it's important to talk about the schools from which these different groups are coming. And what are the characteristics of the K-12 schools that tend to be in heavily segregated urban environments? That in fact that you tend to have a greater likelihood that people will be teaching out of field, that you tend to have fewer AP courses, yes, especially in my fields, that you tend to have fewer AP courses that are offered, that you tend to have less of everything you need in order to be able to be successful. And I think that unless we realize that, then even Texas is going to have an issue. You take his top 10 or whatever, top 10 out of an institution that is not adequately preparing students, or the top 30 out of an institution that may be where you have a few minorities that are there. I think that it's a lot, this is a really complicated issue, but we can't forget the schools themselves. It's not just the people, but what are they being provided in the schools, and what are the characteristics of the schools that are serving these students?
And I think we had this discussion raising the issue of the changing demographics of our country. And if we do not open up pipelines into higher education, we're going to be leaving the majority of our population, a point that, that Gary emphasized, behind. Did I see another hand? Yes, sir.
Hi, I'm a law student, and actually, as to that last point about this, about the K through 12, I've actually had one professor who said, and I don't know how accurate it is, I kind of wanted to get any of your sense of the accuracy, that one of the effects of the 10% plan was actually that students who were at higher performing schools and maybe fell just outside of their top 10% transferred into these lower performing schools so that they could qualify for the into the top 10%, thereby pushing out the bottom of that 10%. I wanted to get a sense of whether you thought that was at all an accurate statement, and if so, what effect that has on those schools, and then potentially, if the new policy is out, or sorry, if the affirmative action policy is out, whether that would have an effect.
My understanding is that that has not happened on any substantial scale. I know, David, you may know a little more about that, but my understanding from the research is that that's something that could logically happen, and it is a strange incentive to encourage students of color to transfer to a weaker high school. It's not what a sensible policy should encourage, but I don't think it's happened on a substantial scale as yet. As the university becomes more competitive and so forth, who knows? But I don't think it's more of a theoretical question. If you think about the structure of the policy, to encourage or to make it much more difficult for a better prepared African American or Latino student to get into the university who happens to be in the 8th or 9th percentile in a really good high school than for one in a very weak high school who happens to be in the top 10%. That's one of the things the university wants to have some freedom for. They don't want to be completely constrained by the mechanics of this program.
Other questions, comments, virtually? Laurie, from our virtual participants?
So this online viewer writes, I think 8 states have now implemented what are being called bans on affirmative action, including in admissions decisions in public higher education. As I read those bans, the relevant language generally reads something like this, quote, shall not discriminate against or grant preferential treatment to, end quote. So my question is, can states in which these bans exist still consider race as, quote, one of many factors in admissions decisions? And if not, why not? Specifically, why does one of many factors equal discrimination or preference?
Liliana?
Yeah, that's a great question on the framing, and that's how so many of these ballot initiatives have been framed and has led to sometimes people signing something that they think is in support of equal opportunity and in fact is undermining it. And the way that the framing of this issue and the public debate is about reverse discrimination as opposed to, which really removes all the consideration of the contextual factors and the historical piece of why it is that we are where we are, in part with the help of legal decisions that have, I think, in some ways facilitated that framing. But the issue, it still covers race-conscious policies. And so what this question raises is that I'm not even sure that what we're trying to defend is affirmative action. We are talking about a policy that has shifted in its definition so much because of these legal opinions that we are just talking about the consideration of race as a factor of a factor of a factor to promote a broad interest in diversity. So in some ways, it's about just considering the individual student fully, all students fully. Students of color who have an experience based on, growing up, whose racial identity can be very, very integral or fundamental to themselves, we're not talking about any, this is about just seeing them as whole individuals in the application process, not about what used to be affirmative action as implemented. And now the political, the broad framing of this issue really ignores that evolution and goes back to try to capitalize on a prior definition that was challenged and had the grounding for why we needed it, but that rationale for addressing past discrimination and ongoing discrimination was taken away at first with the Bakke case in 1978, and so now all that institutions, the sliver that they have to work with is to promote the educational benefits of diversity. And there, we're talking about a very limited policy.
So let me say something about these state bans. They do ban considering race in any way in the admissions process. You can't consider it as one of many factors. That's the point of these propositions. But they do not, some of them do not ban considering race in financial aid or outreach or training and so forth. So Florida, for example, has campuses that have positive outreach. They have targeted financial aid, things like that. Other states, California has no targeted financial aid. The ruling in California has been that it prevents any race-conscious action of any sort. So it'll depend. It would depend on the state. And of course, it'll depend on the court. The court hasn't made any decisions about race-targeted financial aid or other kinds of race-targeted outreach and so forth. That would probably come next if there's an affirmative action ban on admissions.
And in some of the states where they go for resources or funding, where diversity is a requirement of the federal funds, they excluded that particular component.
The questions?
You know, there are 19 states that historically operated separate colleges for black students, which was unconstitutional, of course, and whether or not they've ever completely disestablished that violation is an open question.
And I actually
Texas is one of them, of course.
And
yeah.
our regional.
Yes.
Any further queries from our online collaborators? Okay. All right, unless there's a final, I'm looking at Gary, a final comment, I would close. But go ahead, Gary. Any other final comments from anyone on the panel?
I think whatever this decision is, it's very important for people in higher education and people who cover higher education to think hard about the implications after it comes down. As when we had a decision like this in elementary and secondary, basically the court affirmed the goal and demolished most of the means. Mm-hmm. And many of us are afraid that that might be the kind of shape of a decision that comes now. Hopefully we're wrong. But in any case, the issue is going to be around. And since this is the key to middle-class status in the United States now, higher education is essential in a way that it never was before. Whatever the court decides in this particular case will not be the last chapter.
Well, I think I want to close picking up on that theme. First, I want to conclude by thanking Angelo and Liliana and Gary and Shirley for more than just participating in these cases and in this briefing, but really as all of whom, including our law-trained colleagues, are really accomplished scholars and knowledge producers in their own terms. Liliana's 2013 paper won a very prestigious award from the American Educational Research Association on just these kinds of issues and questions, and to dedicate your career to being in the trenches, as each of my colleagues have, is exemplary. And I want to kind of bring that up to a further kind of reinforcing of why it is we sort of have a, no pun intended, horse in the race as scientific organizations and societies, whether the National Academy of Engineering or the American Association for the Advancement of Science or the American Educational Research Association, and that is out of a really compelling commitment to serve the public good and to make sure that public decision-making is based on the best of what we know at any point in time when there's a sufficiency of the kind of knowledge that can make a difference and when we're all wrestling with very, very difficult issues. And to bring the integrity to the process, a sense of transparency, and a sense of well-warranted, documented data, statistics, and research and findings is just core and central to our mission. And if you haven't observed it, which I hope you do in the months ahead, and I hope many do on the months ahead, one of the hallmarks of how we go about doing this is not just the weighing of the scientific evidence, but for those who are questioning or wondering, has it been weighed right? How are we thinking about this? That on the AERA website, we've asked permission of publishers where we don't otherwise have an open access permission so that we can provide all of the links to all of the information, whether it is the preponderance of the weight of the accumulative knowledge or whether it is critique, so that others can judge in a way that fine science needs to unfold. And on that theme, I want to commend all of you who've come today and have signed in on virtually, because it's been the similar kind of impulse that brings you. It wasn't the wonderful box lunch, as wonderful as it might have been, but it's that you've just wondered, what in the heck do we know? How do we interrogate that? How do we link to that? And how, in a democratic society, can we continue to ensure that decisions, whatever the views you may have had, whatever the views are that you may have in the future, but that when we make decisions, we make it based on evidence, knowledge, statistics, and data, and not just on ad hoc bias or assumptions that really lead in a democratic society to a closed system of operation. So I want to thank you for coming, and hopefully next time, not this year.